Hello and welcome. My name is Beth Kilmarks. I will be your moderator for this for ICA, or the International Council on Archives, EGATT, which is the Expert Group Against Theft, Trafficking, and Tampering webinar on documentary heritage and law enforcement. And so first, I'd like to do a couple of housekeeping items. First, we have the subtitle or closed caption option. So if you click on that, you can get closed captions, or you can do a translation of the language that you select. Next, if you have questions, please submit them into the question and answer box at the bottom of the screen. Please do not use chat. We are just using chat for more discussion rather than questions and answers. And so I would like to start with just briefly describing EGATT, which was established by the ICA Executive Board in 2018. And its purpose is to provide a forum for high-level discussion and expert advice on the fight against theft, trafficking, and tampering of archives. Its work includes the creation of tools and resources to support the work of ICA and its members and the wider archives and records management network. EGATT also provides advice and assistance to ICA elected officers and to the Secretary General on related issues. EGATT also liaisons on behalf of the ICA with external partners and groups working on similar issues and projects. EGATT works closely with the expert group on legal matters and also with the expert group on shared archives, heritage, and other committees also. Some of the projects that EGATT has undertaken to support matters related to, but not limited to, publishing recommendations on prevention and security, organizing training and education, sensitizing the public and the institutions and professionals to these issues, cooperating with other professionals and associations, and also working to ensure the creation and maintenance of a red list of stolen documents. And so what I would like to do is just briefly let you know, inform you of its members. It is an international forum made up of Arda Shalte, who is our chair, and then Megan Guthorn, who is from the United States, Hayada Camille from the National Library and Archives of Egypt, myself, Beth Kilmarks from the United States, Marlene Lopez Torres from Mexico, from the Archivio General de la Nación, Chris Naylor, who is also from the US, Eugenia Serrano Rodriguez from Spain, and I also have Stephen Albert, Helen Vincent, and Marianne Lefferts. And additionally, we have 4 new members who have joined us this past year, and they include Amos Bishi from Zimbabwe, Shirley Franco from Brazil, Buhan Brody from India, and Teresa Powell from the National Library of Jamaica. And so I would like to let you know that this past year, EGATT has been extremely busy in its outreach. We created a seminar series, and this webinar series is number 3 in the series of 3 webinars. And the first had dealt with the experiences of archives and libraries dealing with theft and trafficking, based on a survey created by EGATT. The second webinar was in cooperation with UNESCO's Memory of the World program that we organized, and it was an introduction to the audit tool that we have in order to improve security policies. And so this next and our last webinar series is on documentary heritage. And so I would like to quickly give you a brief introduction to our next speaker, who is going to be Justice Luigi Marini, who served as the Justice and Secretary General of the High Court of Cassation. Previous to this position, he served as a legal advisor at the Permanent Mission of Italy to the United States from 2014 to 2020, with a special dedication to the rule of law, human rights issues, and protecting cultural heritage, with specific work on UN Security Council Resolution 2347-2017, and countering corruption, organized crime, and terrorism. And then from 2001 to 2002, and from 2006 to 2014, he served as the Justice. I'm sorry, in Albania. And from 2002 to 2006, he served as elected member of the High Council of Judiciary, with a special dedication to judicial training and international relations. In the previous years, he served as a prosecutor and judge from 1982 to 1986, and from 96 to 2001, he served as a staff member of the Ministry of Justice. And so without further ado, I'd like to welcome Judge Luigi Marini.
Good afternoon, all. Can you hear me? Is my mic okay, working?
Yes, it's working.
It's working, correct?
We can hear you, yes.
Yeah, thank you, sir. Thank you so much. So, good afternoon, all. I would like to have my presentation will be dedicated to national legislation in the frame of regional and interregional legal systems. And I apologize, from now I have to leave at 5 p.m. for a different commitment. So I'm so sorry I couldn't be present all the webinar long. But as if possible, if you have any question, any comment on my presentation, please don't hesitate to write me or to contact me. You have my email on the first page that is on the screen now. So my first point is the international legal system is a very complex one. I define it as a complex environment. As you see in the screen, the third box of my presentation, there are a lot of international and regional and national sources. You have international convention, UNESCO convention, UNIDROIT convention, humanitarian conventions, the Treaty of Rome, and so on. And then you have sources from UN General Assembly and UN Security Council, and you know how much they are important. But other sources are complementing international landscape. You have UNESCO resolution, UNHCR resolutions, ECOSOC CCPCJ resolution, and then we have resolutions or directives or other regulations and laws come from regional environments. And then, of course, we have international operational bodies like the one is hosting us today, but we have ICOM, Interpol, WCO, and so on. And then we have, of course, national legislations and national regulation in a very, and this is the fourth box of my presentation, very complex relations worldwide. Fifth box, and then we must remember we have international guidelines that are very operational, very important. We have UNODC guidelines of 2014. We have UNESCO operational guidelines of 2015. And we have UNESCO operational guidelines in 1972 conventions. And we have dedicated papers like UNODC 2022 paper on false trade. If we proceed, I would like to underline the UN General Assembly resolution that is known as a crime resolution, that is the resolution proposed by Italy every year now, every 2 years to the General Assembly, dedicated to UNODC plan of actions and to criminal answer to criminal activities. And I would like to remember that, for instance, resolution 187 adopted in 2021, 16th of December, dedicates some important rules to trafficking in cultural heritage. You can find on my presentation. I just want to go to the slide 9, and it is operational paragraph 57 of the so-called Italian crime resolution. And as you see, there are special encouragement to member states to offering special training for police, customs, and border service. And more important even, it invites member states to make trafficking in cultural property and related offenses as a serious crime as defined in Article 2 of the United Nations Convention Against Transnational Organized Crime. This is a very important encouragement that is included also in a resolution of the Security Council 2347, because serious crime is just the basis and the condition for international cooperation at the law enforcement and judicial level. And so the decision at the national level to issue a law that defines a crime and activity as serious crime is basically critical for international cooperation. And this shows how much national laws and national regulations and international dimension are mutually cooperating in establishing an effective legal system. Coming now to, there is one point very important to me, that is that international crime needs international answer. And this means that all relevant legal bodies and organizations should be very clear in having a strong separation between dark markets, gray markets, and official trade markets. Without supporting this separation, we shall continue having gray markets where legal and illegal actions are merged, and these facilitate at a high level trafficking in cultural goods and other criminal activities like money laundering and unofficial transfer of money and illegal transactions can be mixed and with the legal activities, and this will make the work of law enforcement, prosecution, and judicial activities very, very much difficult. There is another point that I want to underline. The regional dimension of our action is more and more critical. Other presentation will target this point, so I don't spend time on this, but I can stand that a regional platform can be positively created, made operational, and become very effective in all regions of our world. So and already many of them exist. And I think the presentation about European Union legal system will be very, very, very interesting at this point. Just a step on UN Security Council Resolution 2347 of 2017. As our coordinator said, I was representing Italy in Security Council for this, with my ambassador of course, for this resolution proposed by Italy and France together. And my experience as judge and prosecutor was important to me for helping drafting a resolution that, especially in the second part, is very operational and contains many important issues that you well know. So I don't spend time on that, but of course, paragraph 8, 10, 17, 16, 12 are contain operational suggestion and calls to countries to be prepared to work on to have specialized bodies, to work on inventories, documentation of provenance, share information between different authorities, public-private cooperation, and so on. So I think it's an important point of reference. So just to come to my very point, that is domestic legislation. Within this kind of framework, I try to summarize in few words. One point from a legal point of view, that is international regulations and international legal systems have their basis in national legal systems. So you know, the international framework is based on state activities, and state activities are based on national legislation and national regulation, national culture. So there is a mutual interference between national level and international level, and they cooperate in advancing our system, looking for common standards and from common rules. I just come to Italy. That's the example I want to introduce in the debate today. You know, Italy has been a very important country in this topic. Italy started issuing law on trafficking cultural property very, very early. Our specific legislation was issued in 1939. Italy created the first dedicated police body in 1969, 1 year before the UNESCO 1970 convention. It was the Carabinieri task force. And so we consider Italy an important country that is sometimes a country trainer for others. But also Italy, in recent times, considered necessary to update its national system in order to be more effective and to comply with international standards and international legislation. And so the law issued in 1939, already updated in 2004 and then in 2009, was furtherly updated in recent times. There are two important steps. One, in February 2022, our constitution was amended. Articles 9 and 41 of our constitution were amended in order to strengthen the protection of environment and cultural items. And in March 2022, the law number 22 was issued. The law is titled Provision on Offenses Against Cultural Heritage. The law was passed by the parliament and contains many important advancements. advancements are on 3 different levels. One is amendments to criminal code. The second is amendments to the proceed criminal code, and the third is at the administrative level. Just one comment on this. Cultural goods, the protection of cultural goods as the other different kinds of protection have different sources of regulation and laws. So you have civil regulations and laws, criminal regulations and laws, administrative regulation and laws that are combined together in order to create the right environment to protect to protect cultural heritage, and they have to be combined in a good manner. So if you advance in the criminal field, but you don't advance in the civil field, and you don't implement or update the administrative fields, the system is unbalanced and doesn't work. So if you want to advance the system, you have to take care at the same time of administrative regulations, of civil laws and criminal laws. So coming to our law, just to be brief, there are, and this is slide number 19 of my presentation, you have criminal code amendments. So new criminal provisions were introduced by the law. So self-laundering complemented the crime of laundering, falsification of private documents was included, illegal import of cultural goods was included. Italy has always been traditionally a source country. And so the previous laws were more interested in illegal export from Italy to other countries. And the criminal provision was the provision of illegal export. But we realized that now we are also a transit country, and in any case, just in order to cooperate with different countries, it was important to introduce also the crime of illegal import of cultural goods. And then we introduced a specific crime that is unlawful possession of soil boring instrument or metal detecting equipment, that is an anticipation of protection. One of the important point is the law increased the range of legal person liability. So coming to the new crimes, we have another choice by our legislator was to increase the level of sanctions. And so the most important crimes are now sanctions with very high level of imprisonment. So theft of cultural goods, we go from 6 to 10 years of imprisonment. Receiving stolen goods, 10 years. Use of cultural goods deriving from an offense from 5 to 13 years, and so on. Laundering of cultural goods from 5 to 14 years. Devastating and looting from 10 to 16 years. So you see, the will of our legislator is to be not only effective, but also very serious. And all these crimes now are serious crime according to UN TOC Convention. And this is important at the international level also for cooperation with other countries. The second point is, from our side, we have a more serious and heavy sanctions. On the other side, we have important increase in criminal procedural code rules. Connected with the higher terms of imprisonment, that is my slide 21. The new system allows prosecutors and judges make easier to issue an arrest warrant to adopt confiscation of cultural goods, and allows law enforcement to proceed with undercover operation, a special police operation by authorization of prosecutor and judges. And then now it's easier for our law enforcement and prosecutors to go on with phone tapping, conversation recording, and also recording of online and conversation and the website and emails and databases. So what I want to say with this reference to the Italian law, please tell me about the time. I don't want to be too long. I'm on time now?
You're just about out of time, so if you could wrap it up, that would be great.
Okay, so the final comment is I want to have with you is Italy has been always on the forefront of working on against trafficking of cultural goods, and we have a strong legislation. We have Carabinieri, TPC, that is at the same time a military law enforcement and administrative corp, and so can provide a strong support. But even Italy in 2022 felt the need to improve legislation and to improve the Italian legal system in order to be more effective at the national and international level. So what Italy decided about harmonization of national legislation with international legislation, it could be a good example for other countries that want to be more efficient, more effective, and more at the national and international level. And I will be happy to go deeper about the new legislation that is very complex. We have more than 30 new articles of the law, but is very coordinated tool and can be offered to everyone as an example to discuss with, to coordinate with. And so I hope this could be useful to all of you. Thank you so much for your attention.
And thank you very much for your presentation, and we greatly appreciate it. If you have questions for Judge Marini, please put them in the question and answer box. And he may not be able to answer them in person as he has to leave the session early, but he will address your questions at a later point. Next up is Marja van Hees. She is an art historian at Leiden University and has been working as a senior cultural policy advisor at the Netherlands Ministry of Education, Culture, and Science, and also as a senior inspector in the Information and Heritage Inspectorate in The Hague. With the inspectorate, Marja coordinates matters regarding EU and UNESCO and goods. And in that respect, she is also involved in several returns of cultural objects to the countries of origin. And she has written several articles on this subject. So please welcome Marja van Hees. Her title of her talk is Cooperation at National and Regional Level Regarding the Protection of Cultural Heritage, New Legal Developments and Challenges for the EU. All right, welcome.
Thank
Marja.
you. And thank you for your introduction. Hello to everyone. As said, I'm going to tell you something about what we do at the Inspectorate and how we work together, both at a national and an international level, and something about the working together within the EU. Next slide, please. So these are our tasks. We are the Central Authority for EU and UNESCO legislation on the protection of cultural heritage, and also for the sanction measures for Iraq, Syria, and Ukraine. We authorize export and import licenses, and we inspect collections of the state, archaeological objects, and governmental archives and records. We work together very closely with customs and police, and with relevant national and international organizations. Next one, please. Next slide, please. So we have a legal framework in the Netherlands, and for us, the most important basis is the Heritage Act, which came into force on 1 July 2016 and was a combination of several cultural heritage acts. Included in this act is, for example, also the EU legislation on import and export of cultural goods, and the UNESCO legislation, the 1970 and the 1954 UNESCO conventions. The sanction measures for Iraq, Syria, and Ukraine currently fall under the Ministry of Foreign Affairs, and the basis for that is the sanctions order. Next one. Documentary heritage is protected in several ways. First, in the Public Records Act, and that has rules and requirements for keeping information in public organizations. This act is going to be revised, and hopefully in next year it will be in force, and it has an important article, new article, with a duty to report incidents or calamities to the Chief Inspector, for example, on missing objects. And the Heritage Act offers more possibilities for the protection, but also for return procedures. In Article 422 is laid down what is legally protected in the Netherlands, and archives also form part of this protection. And in Chapter 6 and Article 8.8, return procedures are laid down once an object has left the territory of the Netherlands, and we would like to ask it back. So that gives more possibilities for the protection of documentary heritage. The Penal Code gives other possibilities. This falls under, of course, under the Ministry of Justice, and the police is here involved with theft and fencing. And once an object has left the territory of a country of origin, also requests for mutual legal assistance and for European investigations orders might be asked for. Next one. We work very closely with customs for now more than 30 years, both on a policy and a strategic level, which is laid down in an agreement between the Ministries of Finance and of Culture, how we work together, for example, on information sharing, but also on an operational level. And important in this field is here to notice that we have a system of training customs, a system of éducation permanente, and every year we come together and we have several themes that we would like to highlight. So this exchange of information on legislation, but also on cases, is important. Customs have an important stop function at the border, and once an object has left the territory, it is much more difficult to ask for its return, and you have to invest more, for example, in high legal costs. So this cooperation is important. And we work also on an enforcement plan with customs and on the basis of risk management and risk analysis. And every year that is laid down. The enforcement plan, how many controls do we perform at hotspots in the Netherlands, like harbors and airports? And we work also on the basis of pilot project and with international programs, for example, on Pandora Athena actions by Italian Carabinieri. Next one, please. And this risk analysis for us, it is based on countries which are vulnerable. For example, for conflicts or for natural disasters, or which have vulnerable cultural heritage like archaeological objects or religious monuments, but also documentary heritage can be vulnerable. And we work on the basis of alerts by UNESCO, by EU member states, by Interpol. The ICOM red lists are for us and customs an important tool to recognize cultural goods. And for us also, research studies are important, either by ourselves or by other countries or other institutions. Next one. And on a national level, this is how it looks in a charter, this triangle with the public prosecutor's office, who advise us and decide on cases which he can bring to court, the inspectorate which can supervise the legislation, and we also have investigative powers. Colleagues of mine are special police investigators, and the national police, of course, there's a special unit of art and antiques criminality, and they can investigate more in a general way. And you see behind this triangle also universities and heritage institutions. For us, experts at these institutions are important to think with us, are these objects authentic, or could they fall under the legal protection of a country? We also have an interdepartmental structure for discussion about strategy on how to fight illicit trafficking. Next one, please. And UNESCO is for us, at the Team International of the Inspector, the heart of how we work together with the EU and with Interpol and the International Council of Museums, the World Customs Organization, and I hope also the International Council on Archives will, in the near future, part of this cooperation. Next one, please. We have several returns in the past years. IFE had to Nigeria, took archaeological objects to Egypt, and also a grave cloth back to Peru. And on our agenda are also upcoming returns to several countries, to Egypt and to Peru and Panama, Costa Rica. So that is good news. And it is also thanks to the cooperation by customs and by police, but also like a Ministry of Agriculture, that we can work together and that we can be successful in returning objects. Next one. Training of customs is important, as I said. Here you see a photograph made in the National Archives, in which the curator explains to customs officers where they can have attention or focus on, and which is important for a library or an archive to keep. Next one, please. And that is research we did in 2012, research on theft or missing documentary heritage in the Netherlands. And I think it is not surprising to you that it is a hidden problem, and that the known or reported cases is not large, but the impact of stolen or missing object is high. It is the loss of irreplaceable objects. And the way of registration, not on an individual basis, but in lots or parcels, that makes it difficult to detect or to discover the object. And also we have noticed that there are not many reports on thefts at national police or within the organization or within institutions who can supervise this, which makes it also difficult to start return procedures because you have to prove what you are missing. And motives are financial, collectors mania, or use for research. And preventive measures is important in this respect, to have a policy on theft and on risk analysis within the organization. And also we notice that legislation is not much known in heritage institutions, the possibilities to start return procedures. And I think that is also important to understand and to be aware of, and to start also awareness raising campaigns on this. Next one, please. So the problems we encounter when unlawfully removed and discovered in the Netherlands: is it legally protected cultural heritage? Is it laid down in legislation? Are there any inventories to prove that an object is from a certain collection? Is there a report of the offense, or is there any photo documentation that can prove it? And also provenance, who is the rightful owner? What is the country of origin? Often this is not complete. And also are there sometimes falsified documents. So that is a huge challenge to find out the provenance of objects. The moment of unlawful removal from the territory is important. For the Netherlands, it is 1 July 2009, and within the EU in 1993. So these are important things to keep in mind, and the terms of limitation of diverse legislation, that can be complicated. And in general, I believe for outsiders, cultural legislation is difficult to understand and to get a grip on. So that's why I think it's also important to work with national authorities or with cultural heritage institutions or within the Ministry of Culture to find out what is the best way to start return procedures. And of course, reportings in databases of stolen works of art. Next one, please. So what is needed for a request for return once an object has left the territory, and when we discover it in the Netherlands? That is documentation to identify an object. Is there a good description, object ID, or photo documentation? Is there any information on the location of the object, or what is relevant cultural legislation? And is there any indication that an object has been unlawfully exported, or that the given provenance is correct or incorrect, or any other relevant information that might help the authorities to help with the recovery and the return of the objects. Next one. And finally, some words on the EU legislation on import and export. That is a complementary system with both protection of legally protected cultural heritage at the inside borders of the EU, and with a system of export licenses at the outside border of the EU. And you need an export license for 15 categories of cultural goods. All cultural heritage is divided into 15 categories. Also documentary heritage, which falls under several categories like manuscripts or archival material or engravings or geographical maps. But then if it falls under that category and it fulfills the age and financial value threshold, you have to apply for an export license. And within 2 days, on 28th of June, there is a new regulation in force on the import of cultural goods, which means that for several categories of objects, either an import license or an importer statement is necessary. So within the EU, we work with expert groups. There are annual meetings on all of these regulations. There are also evaluations, and that is important to understand whether or not a regulation is working or what are things to improve this regulation, but also to reach a level playing field among all the EU member states. Next one. The aim of this new import regulation is within 2 days. No, it is to protect cultural heritage of mankind and to prevent the illegal trade, but also to prevent illegal trade that contributes to financing terrorism. And this regulation gives conditions for the introduction of cultural goods in the EU and for procedures. And an important innovation or new tool is an electronic licensing system, traces, for the import licenses and also for importer statements. Next slide. And this regulation has Article 3 with a general prohibition of the introduction in the EU of cultural goods. And that is comparable with what is stated in the 1970 UNESCO Convention and implemented in our Heritage Act, this general prohibition. But the regulation goes further with Article 4, an import license, which is required for archaeological objects and parts of monuments, which are older than 250 years, whatever their value. And for documentary heritage, Article 5 is important. This is the importer statement. And that is for all other cultural goods, all more than 200 years old, and a financial value higher than 18,000 euro. And also object of special interest and engravings and manuscripts, old books, that all fall under this Article 5, and therefore an important statement is required. Next one, please. There are exceptions for this requirement. So that is for return goods, once they were part or in the EU, were exported and come back within 3 years. You don't need an import license or an importer statement, or when it is placed in an EU refuse to prevent imminent destruction. And when it is temporary on the territory of the EU for educational or scientific reasons, or for sale in a commercial art fair. When it is sold at a commercial art fair, then the importer statement must be translated into or transferred into an import license. So in all cases, you have to fulfill requirements on documents. Next one, please. And this necessary documentation that has several meanings. It is customs documentation, it is sales invoices, it is about condition reports or documentation from exhibitions, catalogs or sale documentation. And that can go back to 24 April 1972, which can be difficult to prove. The challenge is also communication strategy. How do you raise awareness on all these people who would like to import into the EU cultural objects? And also had the close cooperation between the European Commission and UNESCO and other organizations. And how do we cooperate with experts who can identify objects from a country of origin? And when you want to import into the EU an object, you must have an EU login account. So that might raise some problems in the beginning and also demands awareness raising and knowledge how this works in the EU. And of course, we have a level playing field in the member states that every country, every EU member state acts in the same way. Next one, please. So it poses us for questions and huge challenges, but the aim is good. So there is also information on this. The EU has provided a lot of information at their website. You see here the links, and we can send it to you afterwards. And that is what I wanted to say to you, and I thank you for your attention.
Thank you very much, Marja. That was fascinating. And asking everyone, if you have questions, please put them in the Q&A, and we'll try to answer all your questions at the end of this presentation. Next up is the next speaker is Federica Bazzoni, and I apologize. She is a member of ICA's EGATT, and I had left her off the list of speakers, of members of EGATT. And she is Federica Bazzoni, after graduating from the École Nationale des Chartes and the École Nationale du Patrimoine in 1990 and 1991. She held a variety of positions as a heritage curator, specializing in archives within the Ministry of Culture in both central and local government. In particular, she was responsible for the international relations at the
French Archive Director.
At the French Archives Directorate. She has also been a member of the Committee of Experts for UNESCO's Memory of the World Program since 2014 and a member of EGATT since 2020. So, and welcome to Federica, and she will be speaking on the protection of archival heritage in France.
Thank you. Thank you for your introduction. So I will pass quickly on the first two slides because Mr. Marini and Mrs. Van Hees already quoted this regulation in their intervention. But just to remind that regarding the European directive since 1993, there is a missing point. It's the starting point of this possibility of controlling when cultural goods are illicitly exported. The date given by the directive of 1993 is on or after the 1st January of 1993. But as far as I know, thieves generally don't let a card saying what and when they did their theft. So it's very difficult most of the time to check the date when the cultural good is supposed to have disappeared. So we will dive directly in the French national framework. We have a very old country, an old country of Europe, we are lucky enough to have very ancient laws regarding archives, cultural heritage, and namely archives, dating back to the 16th or 17th century, and produced by the administrations in charge of foreign affairs and defense to protect a documentary corpus giving evidence of the national sovereignty. So the Heritage Code of 24 is based on existing text, provides 7 sections, either transverse or thematic, and namely, there is one specifically dedicated to archive. For example, the first law on archive, which is dating back to 1979, and defines for the first time what are archives, and namely public archives, is included in this code that is regularly updated, for example, by including the data, that is to say electronic documents, either native data or created, in the general definition of archives. And so you can see this, this definition, which is very, very, very extensive, very comprehensive, and namely within it, the definition of public archives that are considered as all documents resulting from the activities of the state authorities or local authorities, and also, for example, the minutes and registers of public and ministerial officers, that is to say, namely the minutes of the notaries. This Heritage Code defines what are public cultural goods in general and how they are due to be collected, preserved, controlled when circulating inside or outside borders, and communicated. Furthermore, public archives in France are considered as national treasures, and so they can circulate, namely, apart from temporary project, outside the borders. That is to say that it is impossible to extract any public archive from public holdings, temporarily or definitely, without any official authorization. So any piece retrieved occasionally in public auction or in any other opportunity can be claimed as a public one. And whenever this retrieval occurs, 1 year, 1 decade, or many centuries after the loss or after the theft, the document may be claimed through relevant judicial procedures. And I want to underscore that, as Mr. Marini already said it for Italy, this heritage regulation is also combined with civil or criminal provision and are protecting this heritage, these cultural goods. Here you see some figures about the number of actions made by the French Ministry of Culture for the last 14 years. And even though the curve may seem to have been rising year on year since 2015, this should not hide the fact that each action is assessed on a case-by-case analysis, obviously based both on what is authorized by the Heritage Code, of course, but also on 3 to 4 cumulative criteria. The unquestionably public nature of the document that is claimed, the mention of the document in inventories or any other proof that it belongs to a public collection, the proven historical interest, and the non-existence in public collections or more relevant originals or similar documents. Here you have an example of a public file claimed by the National Archives recently. It's a file on the police investigation into the Landreau case. Landreau was a small-time swindler who escaped from the penal colony in 1914, and he became a serial murderer of single women to whom he promised marriage in order to swindle them. He's likely to have been responsible for about 11 murders, but likely much more. He was arrested in 1919 before being sentenced to death in 1921. And so you can see the marks, the specific marks and stamps of the Préfecture de Police of Paris, top left and bottom right, that helped us a lot to immediately assess and confirm the public origin of this document, and then to launch an official claim to return it to public holdings. But what for private archives protection? The law provides us nowadays with a very extensive definition of what are public cultural goods, public archives, but paradoxically, it's rather difficult to understand from outside. While private archives are defined on a quite blurred and ambiguous way. Private archives are everything that cannot be considered as public. It's not very precise definition. And namely, for example, for political or scientific field, archives of an architect or archives of scientists in charge of public order will be public documentation. But when these people are working for private sector, then they produce private archives. Furthermore, even private material incorporated in public holdings by acquisition or donation is protected by the same legal instruments as public archives. That is to say, prohibition of definitive export, impossibility of sale or possession by private people. And that is the reason why we tried and purchased private archives in auction or from private people. But there are two other tools to protect private archives, namely the datation in payment. It's a way of paying some wealth or inheritance taxes while donating archival corpus of national significance. But as a matter of fact, in archival field, we have very few datation cases operated, the last dating back in 2016. Another tool is the classification or listing as historical archives. It's very particular because the archives remain private archives, held in private hands, but are recognized of major interest regarding their historical, scientific, or cultural value, and thus are covered by the same legal tools as those protecting public collection, and are national treasures as well. So,
excuse me, Frederick.
Yes.
Frederick, your slides are not showing. Could you try to screen share again, please?
Okay. Alors. Is it working? Or not?
Yes, it is. Thank you.
Yes? Okay, perfect. Sorry. So the control about these private archives listed as historical archives remains largely theoretical, precisely because these archives are located all over the French national territory. Nowadays, we have approximately 64 archival corpus listed as historical, and thus to keep an eye even to on them is quite difficult, not to say impossible for local archivists. Ah, ça marche pas. Pourquoi ça marche pas? I have a problem to share. Ah, ça y est. Here we have another example of archives classified as historical archives and coming from a notorious origin. There were the archives of the castle of Vaux-le-Vicomte near from Paris. So we saw when and how these international and European regulations have been implemented in our national framework, but their real efficiency relies, of course, or should I say mostly, on the relationship we may have with various stakeholders and partners. Specifically, how we interact with law enforcement by sharing information, joint meetings with police or customs to share common issues relative to how to improve the cultural goods circulation monitoring, by dealing with specific cases about exportation requests to see whether the request is licit or not. By training, we annually and regularly participate to training sessions for custom agents or judges to award them about what are public archives and how to get in touch when needed with archival agents. relationship with art market is, as you may picture it, more hairy and touchy, because definitely our respective goals are conflicting. The shared standards whom Mr. Marini talked about previously are not shared at all. And the sole common interest being maybe to secure public auctions while providing documents whose origin is not at all dubious. So this connection with the art market actors is built either through recurring contacts with experts, booksellers, and auctioneers at auction, or through regular meetings with professional bodies in a body called the Art Market Observatory. The professional network approach is guided by the specific role dedicated to the French Archives Directorate. This directorate plays a global role to coordinate the national archival network at national or local level and provides both legislation, general legislation and regulation related to archival heritage protection, as well as funding some documentary acquisition. The connection with foreign colleagues is also pivotal for checking the auctions operated outside the national borders, or even for managing the return procedures in case of theft discovery. Professional elaborating various tools addressing the whole heritage public actors and focusing on common concerns and levers is another key action. So we are working regularly since a decade on cultural heritage conservation plans. There are operational documents available to the staff of heritage establishments and the emergency services to deal with situations where heritage assets seem to be at risk. But mostly these documents are focused on disasters such as flood, fire, contamination, but not on the prevention of theft. So we have to include or underscore these points in these documents. We have also various manuals about how to operate a claim on public archives. The first one dates back to 2016, and we have another one in progress that is due to be released by the end of June, and focusing this time on provenance research and fair compensation. And last but not least, we have created an observatory for archival claim since 2021. It is updated each year since then, both for providing the right figures about these public claims in order to fight fake news on the art market, and being able to follow and understand the evolution of our action in this field. Now, to give some illustration about the real story of the most famous theft we have to face last year, I will first talk about the Fier case, named after a thief discovered in Belgium in 2002, who scoured French and Belgian archives for more than 20 years. When he was arrested, we found about 80,000 pieces at his home, which can give an idea of the scale of this unsuspected trafficking operation. The second case is related to the sudden discovery of 30 pieces, archival pieces, released on the website of a renowned Canadian university, actually emanating from a private deposit made to the National Archives, and likely stolen by an American researcher in the 90s, with very few documents retrieved at that date. So the whole material was sent back to the National Archive in 2024 without any legal dispute. And it was very, very good cooperation with the university, this Canadian university. Another Belgian history with 550 documents that were handed over at the end of 2021 to the French ambassador to Belgium as a final part of a corpus sized in 2001 by the Belgian police following the dismantling of a network of thieves and fence keepers who plundered public archives in France, Belgium, and Germany between 1980 and 2001. The last case, but not the least, is the Aristophil affair. It's a very tough legal case relative to an investment fund based on a Ponzi-type pyramid scheme involving about 18,000 investors and related to 130,000 lots, that means millions of documents. The purchase of some lots finance the interest and repayments of other. After several procedures, including Belgian and Austrian subsidiaries, and the liquidation of the company in 2015, an impressive stock of manuscript has been auctioneered through more than 60 auctions since 2017. And before this auction, the public administration tried to retrieve public archives. And so after fast 10 years of investigation, scientific and police investigation, the trial of its manager and experts involved in the misleading assessments, not to say fraudulent assessment. So trial for deceptive commercial policy, fraudulent maneuvers, and gang fraud is scheduled for coming September. The common point I wanted to underscore between all these cases is that most of the time, the positive conclusion is due to a very long and effective and efficient cooperation between archival and police network, and a durable attention and staff availability and accuracy for this case. I will go then to the fact that we saw the legal and administrative disposition likely to provide an effective protection for archival heritage. But there are also technical means that could help. First of all, the archival description. There are many standards for describing archives, ICA among others, but the main issue lies actually on the archival practice. A description not by piece, but by file, or even at higher level, namely for contemporary records. So consequently, we can't have an image for each document, what might be a big problem to identify precisely an archive or to warn the police that it has disappeared. And so it's a big problem both for archivists or for law enforcement agents. So we have to deepen and strengthen security measures in archive premises. And that is the goal of this plan for conservation I talked about previously. And we have specifically to focus on what are the most precious historical documents in each archive services. We have also to improve professional awareness and training about this protection of very important pieces. For example, archival services are often sometimes worn by their own users or even individuals attending auctions or informed of private sales, namely online via websites such as eBay, Katawiki, etc. So that if we were able to more largely and automatically disseminate an accurate information, it could foster a faster monitoring of the market, as well as informing general public about theft shouldn't be seen as a negative publicity for public action, but in the contrary, as a sign of a more responsive and efficient administration. Last but not least, to provide even more training and information to law enforcement services about our professional practices when we need their intervention and how we could work together better. all that could be heard as pushing open doors, but indeed it's because the simplest security provision were not taken for decades or even for centuries, and even continue not to be set up, that we are facing till now so many cases of illegal circulation or theft. So I will conclude by saying that the main goals to achieve now and the future are both simple to say, but probably harder and more complex to set up. It's about deepening cooperation with professional networks. It's about optimizing cooperation with law enforcement agencies at national and even international level, and particularly smoothing relationship with art market, which is quite a critical issue. It's also about developing and implementing professional tools and being particularly more consistent and keen on the research of provenance, which are new issues, but very important ones. It's also being able to defining precise and clearer way of compensating in case of public claim. And globally, generally talking, setting up a more transparent and understandable policy when claiming and returning cultural goods. The key issues about that is to have relevant and evaluative staffing to do the job, and what we can do with artificial intelligence. In what way this AI can help us to be more efficient. So, as said the philosopher Seneca, it's not because things are difficult that we don't dare, so it's because we don't dare that we are difficult. Thank you for your attention, and please feel free to ask if you have a further question.
Oh, thank you very much, Frederic. Next up is A.M. Chandra Badahadur. He will be speaking on the protection of archival heritage in France. He is a crime prevention and criminal justice officer and cybercrime investigation expert at UNIDOC, Regional Center for Combating Cybercrime. Holding a master's degree in computer science and public administration, he brings over 25 years of law enforcement experience, specializing in IT, digital forensics, and cybercrime. His career includes roles such as digital crime investigator to Defer, Timor-Leste, and Kosovo. He excels in establishing cybercrime units, delivering training programs, and managing digital forensic capabilities, and collaborating internationally with agencies, including Interpol. Please welcome our next speaker.
Thank you. Thank you so much for the introduction. Am I audible? Great.
So have you started your slides, your slide presentation?
Now I'm going to start.
Okay. Thank you.
Okay. Is it visible on the screen?
Yes.
Yes, we can see it. Thank you.
Great. Thank you. So yes, good afternoon, everyone. As a cybercrime investigation expert, I will be complementing the topics like legal systems, cooperative efforts, and protection impacting cultural heritage. Those were covered by the previous speakers, but I'll be focusing on the digital frontier and digital domain. The documentary heritage, which includes everything from the ancient manuscripts that are converted into digital format, which is known as digitalization, to the modern born digital files. So there are two formats. One is like converted into digital format. Another is born digital. When I'm saying born digital, those are the digital publications or like electronic records, digital art, and so on. So while digitalization has opened incredible doors for global access, it has simultaneously exposed this to a new evolving set of digital dangers. So my presentation will be focusing specifically on understanding the digital threats, and building resilience. So before we move towards the understanding the common digital threats, let's look why documentary heritage is targeted. The digital realm presents a new battleground for safeguarding documentary heritage. Historically, the focus was on only physical trafficking, but the digital age introduced a new dimension of vulnerability. So I'll be going through the inherent characters of document heritage that makes the document heritage more vulnerable. The first one is digital replicability, meaning it's easy to copy when the documents, when the ancient documents are converted into digital documents and they are stored and they are digitally preserved. It's easy to copy it. It's easy to replicate it and disseminate it easily. So this creates a new vector for the illicit trade and exploitation. So another weakness or vulnerability is accessibility paradox. So this characteristic of document heritage also makes the documentary heritage vulnerable. What is accessibility paradox? It means while digital heritage is more globally available, it is also more exposed to threats. The commitment to make the information, the document heritage information freely available and widely available to everyone with minimum restrictions is making it vulnerable to the cybercrime threat actually. So these are the two basic characteristic of documentary heritage, which makes it more vulnerable to the cybercrime. So I'll be going through common digital threats. The first one is digital obsolescence. This is when attackers trick people into doing something they should not, like clicking a bad link or giving away a password. It's often done through fake emails, text, SMS, or phone calls that look legitimate. I will give an example. For example, an archivist receives an email that looks like it's from the IT department, urgently asking them to verify their account by clicking the link. The link leads to a fake, urgently asking them to verify the account login page. When the archivist enters the username password, the criminals steal them, gaining access to the internal work. The second one is, this is when attackers trick people doing something they should not be clicking. This is infodemic and dissemination. The third one is cyber attacks on archives. The archives are targeted. So there are few more digital threats which fall under cyber attacks. The first one is phishing. Second one is malware viruses. When I'm going through this slide, I'm sure that this will be a kind of cybercrime awareness session also, though I will be focusing towards the documentary heritage. This is harmful software designed to damage computers, steal data, or cause problems. It can spread through infected files or websites. Let me also provide you an example. A staff member unknowingly downloads an infected document from a seemingly harmless website. This malware then quietly installs itself on their computer, perhaps recording their keystrokes to steal passwords or even corrupting files stored on their network. There is one more digital threat within the cyber attack archives on the archive, that's insider threats. So these are risks that come from within the organization, within the institution. They can be from employees, they can be from contractors, or they can be from third-party vendors. Example of accidental, it can be accidental or it can be malicious also. So if it, let's take an example of accidental. A librarian trying to quickly transfer sensitive research data saves it to an encrypted personal cloud storage, which then gets compromised by an external hack, unintentionally exposing the data. I'm sorry if I'm going more technical. I'll try to be more generic. So another example of malicious can be like a disgruntled IT employee before leaving the institution intentionally deletes the critical historical databases or archives, knowing they have access permissions to do so. So this is another threat. Data breaches. This happens when unauthorized people gain access to sensitive information. So another most common digital threat is denial of service. For example, if the ancient document is digitally preserved, and if it is there on the website and people are trying to access it, if people cannot access it, this can be because of denial of service or distributed denial of service, which means there will be more traffic to the website and the user will not be able to access the data. The final threat on my slide is about the ransomware. I'm sure we all know about ransomware, but I'm sure that you are not victim of ransomware. This is the time of malware that locks down your computer files or entire systems and then demands money to unlock them. So now, until now, we have gone through the digital threats, common digital threats. Now let's understand how to develop defenses. That's building resilience. When it comes to the building resilience, the first one is prevention. It involves proactive risk assessments and building robust cybersecurity infrastructure. Apart from that, as previous speakers already said, training is also important. So regular staff training about the phishing, using strong passwords, using multi-factor authentication, safe browsing, email hygiene, how to report the suspicious activities. And apart from that, institution or organization can also come up with the clear policies and procedures. The second is protection, which means implementing strong access controls. This falls more into technical side. Robust technology should be used. Maintaining firewalls. Third one is detection response, which includes IRP. IRP is like incident response planning. Once the data has been exposed to the criminals, if we have IRP, if we have backup plans, robust backup plans, then this is how it can be restored. So in the cybersecurity domain, there is a golden rule that says like you have to back up the data 3-to-1, which means you make 3 copies of the original data, keep those data in the 2 different places, 2 different storage media. 1 copy should be off-site, not onto the on-site. So these are the recovery strategies. Apart from that, there should be continuous adaptation. Like cyber security is an ongoing process. The cyber threat landscape is dynamic. Today's solution may be tomorrow's vulnerability. So therefore, cyber security must be viewed as ongoing iterative process, not a completed project. Embracing new technologies safely should also be considered. Then the specialized skills trainings should be taken care of this. So international collaborations. Previous speaker talked about the international collaborations. Most of the participants from the Europe, they all know Budapest Convention was a groundbreaking treaty, right? But its membership was largely to the European. So there is one convention being pursued to create a truly global legal framework that accommodates diverse legal systems and emerging cyber threats. Article 35 of this Cybercrime Convention talks about the international cooperation. It was adapted last year, 24 December 2024, and this will be open for signature in September 2025 in Hanoi. So this will come into entry into force after 90 days of the signature and ratification. The Cybercrime Convention 5 facts. I don't know whether if I play, will it be audible to you or not? Let me try.
Okay, well, thank you very much for your presentation. And moving on to our last speaker is Murat Yildiz, who is going to be speaking on criminal exploitation in cultural heritage crime dynamics. He is an expert and seasoned criminal justice practitioner in international security, specializing in trafficking in cultural property, transnational organized crime, and illicit trafficking. With over 25 years of experience, he has worked with prominent international organizations, including the United Nations Office on Drugs and Crime, and the Organization for Security and Cooperation in Europe, and the International Institute for Justice and the Rule of Law. He is presently trafficking in cultural property lead at UNOC. So please welcome our next speaker. Are you able to share your screen? Oh, yes.
Yes, is it coming
Thank
now? Well, thank you very much for the introduction. I appreciate the invitation and happy to speak to in this interesting and important event. And it's always difficult to be the last speaker, isn't it, even in the afternoon? But I hope my slides is going to be interesting enough to keep you focused. Yeah, I'm working for the United Nations Office on Drugs and Crime. As the name suggests, we mainly deal with all various types of crimes, which includes organized crime, and under which the trafficking cultural property as such remains an important thematic folder for us. And today I'll briefly talk to you about what are the threats, what are the evolving patterns, and how we can work together, and what UNODC has been trying to sort of help and assist member states. We're based in Vienna, but we have a footprint in 154 member states across 5 continents, working shoulder to shoulder with law enforcement and criminal justice agencies in preventing, investigating, prosecuting transnational organized crime, which includes trafficking in cultural property. And I'm proud to be the lead in that portfolio. So the documentary heritage is growing, as previous speakers has already mentioned several times. And with the development of information technology and the tools that we have, it's providing access to documentary heritage in a multiplying growth of information. So as the threat, as my colleague just mentioned about potential cyber threats to documentary heritage, so we need to be also very agile and responsive. So in my slides, we'll talk about criminals, how do they use the documentary heritage as a target and as well as a tool? And so cultural heritage crime is not limited to artifacts. Documents themselves are also exploited. As previous speakers have mentioned, criminals forge or alter ownership records, provenance documents, export-import licenses, registries, and other forms of documentation to launder the looted cultural property and cultural heritage. These falsifications are increasingly digital and hard to detect, as UNESCO stresses that the preservation policies must anticipate that the criminal misuse. I mean, from UNODC perspective, I think Interpol, Europol, and other international law enforcement agencies will agree with our assessment that we have been witnessing quite increasing number of big footprint in the criminal domain. So criminals are using the cultural heritage, documentary heritage for various purposes. Unfortunately, the time is very limited, so we can't go into details of those things, but I hope this event will provide us an opportunity to continue the discussions in different formats in later on. So when we look at the digital access, so the criminals use and manipulate the data, forge digital certificates, and use different tools like deepfakes and synthetic documents. So what we need from the criminal justice perspective is the digital openness, as my colleague just mentioned, strong audit trials, authentication systems, so that we can do that. If we look at the exploitation in practice, and what are the criminal business models? So criminals use the document heritage both as a target and tool. And when we look at the examples, the organized theft of rare books, as you have potentially seen in the international news items, that books are original, stolen, and replaced with the fakes and sold in the auction houses in various countries. And this is one of the examples that you see on your screen in 2023 and 2024. There are cases of these rare books stolen in libraries and replaced with the fakes one in some cases and sold in the auction houses. So if you look at the other countries like Ukraine, they report more than 360,000 documents being looted during this war and conflicts. And so the cultural heritage, documentary heritage is always becomes a victim of international conflicts and wars. And these crimes often escape notice, unfortunately, due to lack of technical expertise among many investigators and frontline officers. I mean, another example is here, and like the archives in Lebanon was also being destroyed and damaged. So these are all targeted attacks that are sort of taking out the cultural heritage and documentary heritage in the hands of the population. Unfortunately, I mean, there are sometimes targeted attacks, there are sometimes collateral damages in the libraries and archives, which is impossible to replace those common heritage. So there are examples that we can talk more about the deliberate actions by terrorist organizations like ISIS, where we have Mosul University Library being destroyed, when you have Timbuktu manuscripts burned in 2012, and you have very, very other cases, unfortunately. Like if you take the Sudan into account, the National Museum and Archives in Khartoum has been looted. I have been speaking to the Sudanese colleagues recently that unfortunately the situation is very desperate, that even it's very hard to take stock of what has been stolen. So this is how much we are in sort of in lack of information in these cases. So if you look at this, these are the sort of real images from the burned manuscripts from the Mosul University. So that's impossible to return them back. And this is from Timbuktu, and then you can continue. There are tons of examples in the history. You can go as early as possible. There's always the cases that libraries, museums, digital archives became a victim, sometimes a desperate target for cultural heritage related issues. So what we have in the international tools, and the Judge Marini mentioned quite in details about the international tools, conventions, UN Security Councils, Of course, coming from United Nations, we always sort of promote the UN Convention on Transnational Organized Crime, where we work together with UNESCO, Interpol, and all international regional organizations, criminal justice agencies, to help assist member states. What we have, one of the tools, I guess this has not been mentioned yet so far, these 2015 UNESCO recommendations, which emphasize preservation, access, policy, and the cooperation in reference to the documentary heritage. So when it comes to criminal exploitation of documentary heritage, which violates cultural rights and right to information and public access to justice. So this is something that we encourage states to strengthen their legal and procedural responses to protect archives and documentary heritage. The previous speakers mentioned the need for actually raising awareness, training law enforcement, but this is something that UNODC has been very proud to support criminal justice agencies, in particular the law enforcement. So what we do, in fact, in practical terms, like end of this week, I'll be traveling to Cairo, where we will be training judges, prosecutors, law enforcement officers, investigators, and the cultural heritage experts on document fraud detection. This is something that even previous speakers also mentioned, very important topic. So we feel that there's a lack of knowledge, skills, and capacities in various countries. So we bring in the expertise available to member states so that they can be more vigilant, more agile, more responsive at the front line with the customs, law enforcement, border guards, even even the military in some cases, that they can respond to the trafficking or in various associated crimes on cultural heritage and documentary heritage issues. So we provide a number of training, like one of which is the open source intelligence training. While the previous speakers were presenting their topics, I was also trying to answer the questions. I guess in some of the questions, I have already covered these issues, that UNODC is a specialized entity, international organization in filling the knowledge gap in various areas in the law enforcement, criminal justice. And this open source intelligence is one of the tools. I guess this would be also the answer to the question on the Q&A part, that how member states can detect the object that are outside of their jurisdiction. So the open source intelligence is one of the tools that criminal justice agencies, even ministries of cultures, apply quite often to identify objects that are on either e-commerce websites, on Facebook, on digital platforms, on social media, in auction houses, catalogs, or on web, whatever you just name it, so that they can detect the object and then start the official procedures to claim and ask for restitution and repatriation of the cultural heritage items. So we also sort of provide these things, and we, as I said, we provide a number of capacity building assistance. We try to understand how criminal networks have been working. Actually, this is one of the niche areas that UNODC is very proud of it. So we speak to traffickers, we speak to criminal justice authorities, we speak to private sector, the auction houses, the private collectors, to better understand what is the area that criminal justice authorities needs to focus on, what is the sort of weakest ring in the chain, and what are the business model and modalities. For example, recently we have been in Ukraine trying to understand how war is impacting trafficking cultural property and the damage on and how the criminal networks are coming into the environment and work together with the other criminal networks and exploit the environment and take as many as possible cultural heritage objects out of the country. So these are the areas that we try to sort of focus on. We also understand that there's a huge gap in understanding in the criminal justice authorities, in particular for the prosecution and the judiciary. We also provide sort of specialized, tailored training assistance for the judges and prosecutors. Like in coming months, we'll be doing in Egypt and in Lebanon. We've done similar trainings in Ukraine. So we take what is called a whole government response to that. What we have been experiencing that focusing on one element in the criminal justice system or in the government system is producing some results. But however, if you target the whole system and provide an assistance that it covers all institutions as such, then the chances of responding to this crime, and also increasing the number of restitution and repatriation and taking the items in from the hands of criminal organizations is more successful, more productive. So in particular for combating documentary heritage crimes, again, the whole government approach is very important. So that you need to be sort of raise the awareness, not only in the law enforcement, not only in the customs, police officers, border guards, but also in the educational system, in the public domain, and in the cultural heritage domain, as well as in various other institutions. So my colleague mentioned that we are very proud that now we have the Cybercrime Convention, in addition to the other international legal frameworks, which will hopefully facilitate more robust and effective cross-border cooperation in detecting these objects in the cyberspace, even sharing information and evidences, and also facilitating mutual legal assistance, which will provide member states to share evidence across the border so that they can move forward with their prosecution and jurisdictions. Very briefly, I know that the time is very limited, and there are a number of tools that I would like to bring into the attention of participants, which we hope that it's going to be of a good use for them. You see on our screen that we have a database which is called SHARLOC, Sharing Electronic Resources and Laws and Crime, in which this is publicly available and available in 6 UN languages. You don't really require to have a sophisticated password or username system. You can have a direct access to that, and you can look into the legislation databases by filtering different types of crime, in which we have a number of national legislations on trafficking cultural property. We have case laws, we have a number of treaties that are available. I know that previous speakers also talked about the knowledge product on our website, that I'll leave it to you that you can take a look at it. Now, I'll leave this last slide on the screen so that if you want to take a picture, which will give you a QR code into all resources so that you will be able to take a closer look and deep dive into our knowledge products. So with that, I have to unfortunately conclude my presentation. We're already beyond our time limit. And as I said, during the presentations, I tried to answer as many questions as possible. However, if you have any further questions, I'll be very happy to answer. With that, back to you, Beth. Thank you.
Thank you very much. That was absolutely fascinating. I enjoyed your presentation, as I enjoy the presentations of all our panelists. Thank you for attending EGATT's third webinar on documentary heritage and law enforcement. And with that, thank you all and have a good evening.
Thank you.
Bye.
Bye.
Thank you.
Goodbye. Thank you.